All right, hello everybody. This is Search and Seizure in Golfballs, where I will teach you a little bit about search and seizure, and then Eric will tell you everything you want to know about not hitting someone with a golf ball and getting blamed for it. I don't know. Oh, can I have a quick show of hands? Who knows a little bit about Eric's story or has heard it before? Oh, okay. Fair amount of people. If anyone else is confused after we're done talking, talk to one of the people who just raised their hands. They'll explain. All right, my name is Jim. I am a criminal defense attorney. I've been practicing here in Vegas for the past 3 years or so. Eric is but a modest hacker and was minding his own business one day about 2 years ago when he found himself arrested by the Seattle Police Department. So what I'm going to do then is I'm going to talk a little bit about search and seizure law, when the police can stop you, when you can be searched, what the law actually is, and then we're going to see from Eric's experience how the law is actually applied by the police. And you might see a little bit of a difference between the two. And we want to have time for questions at the end. Hopefully we will have time to have questions in here. If we don't have time in here, we'll be in the Q&A room over there, 113. Thank you. After this. Okay. Oh yeah, I have to give my legal disclaimer. Because I'm a lawyer, I have a legal disclaimer, which is that you should not take legal advice from some guy talking at DEFCON. If you actually get arrested, hire a lawyer or get the public defender or whatever, but don't take my advice as the gospel truth. I only have 20 minutes to instruct you on law that took me at least 3 or 4 months of law school to learn. So I'm not really going to cover everything, okay? And don't try to play gotcha with me either. I know I'm leaving stuff out, okay? I speak from experience with hackers. Okay. All right. Now, search and seizure law is mostly based on the federal Constitution, the Bill of Rights, the 4th, 5th, and 6th Amendments. This is stuff that they really should have taught us all in high school. Instead of telling us about the bill on Capitol Hill, they probably should have told us what to do when police stop you and when police can stop you, because honestly, that's the interaction most of us have with the police or the government more often than passing bills and the executive branch and blah, blah, blah. However, they don't teach us this stuff in high school, so that's why I'm going to give a little primer, give you a little framework to understand what happened to Eric. So there's basically 3 different levels of when the police can stop you. There's the voluntary stop, investigatory detention, also known as the Terry stop, and getting arrested. And that's going from least serious to most serious. All right, so the first one is the voluntary stop. And that's a fancy legal lawyer way of saying, a police officer says, hey, can I talk to you? And you say, sure, why not? Ta-da, you've had a voluntary encounter with a police officer. This is when both of you are agreeing together to have a conversation, or at least that's the way it's framed. The officer's going to say you're both agreeing that you're having a conversation. Maybe you're kind of a little bit intimidated into having a conversation. Now, this can last as long as either one of you want it to. And there's completely obviously legitimate reasons to talk to the police officer. It's not all you might get in trouble. Everyone's had a situation where they actually call the police and want the police to help them. So it basically lasts until you've both decided to stop talking to one another. And the way you know it's a voluntary encounter versus something more serious that we'll get to is that you are free to leave at any time if it's a voluntary encounter. If you ask the police officer, hey, I'm done talking, is it okay if I leave? I have someplace to go. If they say no, then you're being detained. You've been seized by the police officer. This almost isn't a seizure, but officers can use a lot of tricks to keep you kind of intimidated where you'd like to say, I want to leave, or, I'm kind of done with the conversation, but, they're a police officer, they have shiny badges and uniforms and guns and things, so they might try to tell you can stick around, that you should stick around, but you have a right to walk away from a conversation if all it is a voluntary encounter. And my advice to you is to be polite to the police officer. Be helpful if you want to be helpful. You don't have to be, but at least be polite. Don't turn on full asshole mode at the beginning. If you're walking by and the cop asks you what time it is, don't be like, oh, am I free to leave, officer? Are you detaining me? Just be cool with the officer, and they're people doing their jobs too, all right? They might have a different outlook on some things than you or I do, but they're doing their jobs, and they might be having a bad day. Just play it cool, and hopefully you won't escalate to the next level of a police encounter, which is an investigatory detention, which is also known as a Terry stop for the famous case Terry v. Ohio. which says the police can stop you when they have reasonable suspicion that a crime has occurred and that you're somehow involved. And as you'll hear from Eric, this is pretty much the situation when they first showed up on the scene in his case, arguably. I saw you were about to argue with me, don't. All right. And basically, the cops get a call. In Eric's case, it was these guys are screwing around with golf balls, and they hit somebody, and they show up. And at this point, they're investigating whether a crime has occurred. They don't really know. I mean, someone calls 911, but they don't know if a crime actually occurred, if it was a prank call, if it's something serious, not serious. They don't know what's going on. So they're showing up and trying to figure out, is there a crime? Is that guy involved in the crime? What's going on? So they're allowed to hold the person there until the suspicion is confirmed or the suspicion is evaporated or dissipates or whatever fancy word you want to use. Dispelled, sure. That was geeky. All right. So they can stay there, and basically they investigate, and if they decide after some investigation that they got the wrong guy, they're supposed to let the person go. And at that point, it goes back down to the previous level of the voluntary encounter. I mean, if they're letting you go, you can stick around if you really wanted to, or you can leave. Or it gets escalated to the next level, which is you got arrested because they confirmed the suspicion that there was a crime. So this is a kind of in-between place, and because of that, your rights during this time are pretty unclear. You always have your rights, we'll talk about later, the Miranda rights, like to remain silent, to have a lawyer. You always have those rights. Those are constitutional rights. But it's not really clear if you have any special rights. They don't have to remind you of them at this point. They don't have to read you your rights at this point because they're just investigating. It's also unclear how long they can keep you in this kind of twilight zone of investigating but not charging you with anything, not arresting you. The courts take it on a case-by-case basis. They can't, I think, it's usually like if you go past an hour or two of standing on the side of a road, the courts are kind of like, yeah, they should probably let you go. Or they should, they can always come find you later if they need to. There's also a question when they're investigating whether or not you have to identify yourself to police. And this is especially true in Eric's case, which is why he's here to talk today. The answer to that is it depends what state you live in. There was a Supreme Court case called Hibble that was out of Nevada. Nevada has what's called a stop and identify law, which says if you're being stopped and investigated by police for some crime, you do have to identify yourself. And the Supreme Court said that law is fine, but it's up to the states. So here in Nevada, if they're investigating something and ask you to identify yourself, you do have to identify yourself. In Washington State, where Eric was detained, there is no such law. And he'll talk about what'll happen because of that. But there is no such law there. If there's about 15 states that have stop and identify laws, you can Wikipedia it later. I don't have a list in front of me, but you have to check on whatever state you're in as to whether you have to identify yourself to police. When you get stopped in this way, before you get arrested, so you're not arrested, you're stopped by the side of the road, they can only pat you down for weapons if they have a reasonable suspicion or idea that you have some kind of weapon on you. They don't just get to search you if they've stopped you like this. They can search you only for weapons, only if they have some suspicion that you have a weapon. Maybe the 911 caller says, oh, I thought he had a gun. Well, then they can pat you down. But they can only pat you down to make sure you do or don't have weapons. They're not allowed to go into your pockets. They are not allowed to feel something and say, oh, that feels like a wallet. I wonder what's in there. Let's take that out. No. They basically get to feel you up. If it feels like you have a gun or a knife, they can take that off of you, but that's it. They don't get to search anything else. They don't get to look inside things. Nothing like that. They can always ask you on this level or the previous, on a voluntary encounter, they can ask you for permission. If you want to let the officer search you, you can, of course. I wouldn't recommend it. And this, of course, leads to many police reports where they claim that the person let them voluntarily search. Whether or not that actually happens is in question many times, but you have a right to not be searched basically up until this point. And again, this level is very vague. This investigatory detention is very vague about your rights and what you should do. Again, just remain polite, remain cool and calm, as you'll see Eric doing for the most part throughout his encounter. And try not to get arrested. Which leads us, oh, come on, open office. There we go. What was that? What's a weapon? It's something that can be plainly identified as a weapon. So if you have some crazy like ray gun or something, then probably If it feels like a gun, then they get to take it away. If it feels like a knife, they probably get to take it away. Something you can hurt people with.
They can't argue that your cell phone might trigger a bomb.
That's getting a little ridiculous.
What about a hammer?
They could probably, like, if you have a big-ass hammer just hanging off your belt, they probably, yes, could, like, just put it over on the side for a little while. Stuff like that. All right. Yes, yes. All right, it's not lawyer gotcha time. Let me continue. You can annoy me about what's a weapon during the Q&A. All right. Level 3 is arrest. They get to arrest you if they have a warrant for your arrest. Big shocker. If they actually see you committing the crime, then they get to arrest you, of course. And if there's probable cause that a crime has occurred. Do not ask me to define probable cause. That will take too long, and we'll be here all day. Probable cause is more than reasonable suspicion, If they show up, let's say, to a scene, 911 caller says, oh my gosh, there's a bank robbery, a guy with a black t-shirt and camouflage shorts just robbed the bank. They show up, and I'm still standing around, and 10 people from the bank says, that's the guy right there. Obviously, the police didn't see me commit the crime, but at that point, they have probable cause because 10 people are all pointing at me and saying he robbed the bank. Whether or not I actually robbed the bank is the question for the trial, which is way down the road. Right now, we're just dealing with the police. So basically, once you get arrested, they get to keep you as long as they want to. You have to be charged within a certain amount of time. That's a different thing. And they basically get to keep you until you're charged with a crime, not charged with a crime. And if you're charged with a crime, then bail has to be set, etc. You do get to be searched when you're arrested, and that's a full-on search. Your pockets are going to get emptied. They're going to take an inventory of everything to make sure nothing gets stolen or you don't accuse them of stealing anything, right? All right. And if you're driving your car when you get arrested, there's many, many rules about what part of your car gets to be searched. I'm going to say the short version is if you get arrested while you're driving your car, yes, they can search your whole car. So if you're carrying around your weed in your car, bad idea. They will find it if you get arrested. They also obviously get to search you, and they get to search anything within basically your arm's reach around you. They get to search if you're arrested in your house. What are your rights at this point? It's your Miranda rights, and I'll go into more detail in just a second. I'll just do it right now. And then my advice, of course, is for you to shut up. But there's a caveat to that. Once you're arrested, you have these rights, the right to remain silent and the right to an attorney. And the other ones in parentheses are special. If you're a kid under 18, you have the right to have your parent present in any questioning. And if you're not a U.S. citizen, you have a right to someone from your home country's embassy or consulate you have a right to have them come help you, come talk to you. But anyway, the main two are the right to remain silent and the right to an attorney. So this year, the Supreme Court decided one of their stupidest criminal decisions in a long time. Because previously, the way you exercised your right to remain silent was you were silent. And that makes a lot of sense. If the police are talking to you and you're sitting there not saying anything, and they keep talking to you, you're not saying anything, you're quiet, well, clearly the person's choosing to remain silent. They're exercising their rights. And the point of that is, at some point, the police need to stop asking you questions, stop being intimidating, let you remain silent, because that is your right, and leave you alone. What the Supreme Court said this year, I don't remember the case name, but they said this year, in order to exercise your right to remain silent, you must tell the police officer that you want to be silent. So, what you have to do is once you get arrested, you must say, I want to remain silent, and then remain silent. And then that'll work. And then they have to leave you alone and not question you about what's going on. You also have the right to an attorney, and you have to say, I want to talk to my attorney, or I want to see an attorney, and then stop talking. If you put any qualifiers on it, like I probably want to see an attorney, I think I should see an attorney, it's a good idea, it doesn't count. There's many, many cases on this. It doesn't count if you put any kind of qualifying language. All you have to say is, I must see my attorney, or I want to see my attorney, the end. So, you have to actively invoke your rights. There's no more passive courts assuming that you want to exercise your rights. You actually have to step up and invoke your rights. So, if you ever get arrested, please step up and invoke your rights. They're there for a reason. They're there to protect you. All right. You ready?
Yeah.
All right. Cool. So now that's the basic framework, the 3 different ways the police can stop you. And as you'll see, Eric's experience was we kind of